morning, and thank you for registering for today's webinar. My name is Laurie Denham, and I'm the uh, chair of the Professional Development Committee for NABE, and I'm thrilled to be able to present these two speakers today. I have heard sessions that they have done early on that were excellent, and as we all know, the landscape keeps changing, and both Kevin and Jeff are updating this presentation constantly and also are able to bring the information they've gathered doing other webinars that are similar for questions that have been asked and input that's been given. So without wasting any more of your time, I'd like to introduce Jeffrey Tenenbaum and his law partner, Kevin Serafino. Their group, the Tenenbaum Law Group, is in Washington, D.C. Both are very long-term attorneys that have helped in the association community for many years. In fact, this year received the award as the ASAE TARP Partner Award. So now I'd like to turn it over to Jeff and Kevin.
Thank you very much. And hello, everyone. Just so you know our background, I'm managing partner of Tenenbaum Law Group. My colleague Kevin Serafino is an associate in the group. We're a 6-lawyer law firm based in Washington, D.C. We exclusively represent associations and nonprofit organizations as outside counsel, representing hundreds of associations and nonprofits each year. And our 6 attorneys provide advice and counsel on the broad array of all of the different legal and tax and regulatory issues that associations and nonprofits face. And we actually represent some of your organizations that are represented here on the call today. So one of the areas that, not surprisingly, we've been spending a lot of time counseling our clients on, especially for the last almost 3 months now since the new administration took office, is the fallout for associations, including bar associations and other nonprofits, from the new administration's kind of anti-DEI focus. And this kind of caught everyone's attention for sure. And days 1 and 2 of the administration, January 20th and 21st, when among many, many other executive orders signed and issued by President Trump were 2 kind of anti-DEI related executive orders. Those executive orders made clear that it is the policy of the new administration to oppose any what the administration calls illegal DEI, whether it's in federal agencies, in the federal workforce, in federal funding, and in private organizations, including private nonprofit organizations as well. In fact, one of the executive orders even called out bar associations by name as an example of a list of private nonprofit organizations that the administration is trying to root out illegal DEI activities. But I'd say the primary focus of the executive orders, and the executive orders don't have the force of law, they're not self-executing, but they did direct other federal agencies, from the Attorney General to others, to every federal agency, to do a number of things in this area, and it certainly has had that effect. But I'd say the primary effect of the executive orders per se, which have gotten all the attention, has been on federal funding. And federal agencies as well, but that's not our focus today. It's representing bar associations and nonprofits, but on federal funding. And as I'm sure you've read and heard, there are plenty, hundreds and hundreds, if not thousands, of nonprofit organizations, thousands of for sure, that receive federal fund or did receive federal funding, whether through grants, cooperative agreements, or contracts, either directly or indirectly as subaward recipients, who have had those funds either reduced or cut altogether. And some of the targets of those cuts have been organizations and programs they administer that deal with categories and topics that the administration would deem to be DEI related, and certainly plenty of others as well. Basically, anything that does not conform to the administration's priorities is being cut or is in the process of being cut or eliminated. And that's clear across the board, not just illegal activities. It is definitely not just waste, fraud, and abuse. It's much broader than that. It's anything from DEI related activities to conservation activities, clean energy, immigration rights, you name it, across the board. Any priorities, programs, initiatives that you would probably categorize on the left side of the political aisle are being cut or eliminated by the administration. So that's been the primary focus, and certainly any organizations that receive federal funds have certainly been scrutinizing their conduct from a DEI perspective. But as we're going to get into, it's much broader than the executive orders. It's even much broader than the administration. And while the administration's executive orders and overall focus have kind of fanned the flames of the anti-DEI sentiment in parts of the country and have certainly spawned a lot of private litigation and other enforcement actions, including outside the federal government. There's a lot of the primary risk to organizations like yours have actually nothing to do with the executive orders, which is what we're going to get into. And that story hasn't gotten as much attention, and it has to do with employment, it has to do with contracts, it has to do with federal tax exemption, it has to do with the states. And we're going to talk about all of those things today. So Kevin and I'm going to turn it over to Kevin in a minute. He's going to walk you through a little bit of the chronology, how we got here, but really focusing on what are the primary risks that bar associations face in this area, and most importantly, what can you do to mitigate those risks? So Kevin, with that, I'm going to turn it over to you, and I will chime in on occasion with commentary.
Thanks a lot, Jeff, and good afternoon, everyone. Like Jeff said, I'm going to just spend a few minutes kind of getting into the time machine for a minute and getting back into the early days of the second Trump administration to just give you a quick recap on the executive orders that we've been talking about, and then some of the kind of sub documents that we've been seeing implementing these executive orders by various government agencies, and a couple of legal challenges. And then Jeff is going to get back into some of those, kind of primary risk areas that he mentioned: federal funding, employment, contracts, and state law and tax exemption. But just to kind of, again, get back to January 20th, on President Trump's first day in office, he issued an executive order on January 20th that we're going to call the Environmental Justice Executive Order. That directed the termination of all discriminatory programs, including illegal DEI programs, policies, mandates, and activities within the federal government under whatever name they appear. So this was specific to environmental justice programs that have been implemented under the Biden administration. It also directed federal agencies to submit a list of any federal contractors who had provided DEI training or materials to federal agencies and employees. Since the Biden administration began. The second executive order that we're talking about was issued the following day on January 21st. And this one was much more specific to DEI programs writ large, but also in the private sector. And there's a lot of overlap with the terminology and the kind of the broad policy statements of the first executive order. But the second one, again, makes a broad policy statement declaring, telling all government agencies to terminate a long list of, different kinds of programs. Let's see, they directed agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. Now, a lot of those are kind of saying the same thing, but I think it just really just goes to back up the notion that this is a very broad-reaching policy statement. And it went even further by, using, political rhetoric to describe DEI programs as dangerous and demeaning and immoral. So we see kind of a combination of a broad policy statement with significant and negative political rhetoric. It also directed federal agencies to require federal contractors and grant recipients to certify that they do not engage in any illegal DEI. It also singled out different kinds of entities in the private sector for enforcement, particularly large nonprofits and foundations, bar and medical associations in particular, and higher education. And we've all seen some of the actions that the administration has taken against institutes of higher learning. So, I think one of the things that's really worth addressing in the executive order text is how it really doesn't talk about what illegal DEI means. It makes very vague and tangential references to two areas of law, those being the Civil Rights Act of 1964 and the Students for Fair Admissions cases that were decided by the Supreme Court in 2023. Those were the affirmative action cases involving Harvard and the University of North Carolina. But other than that, there are no legal citations here. This is not a legal document. So, we're left to wonder what illegal actually means. But the
And let me chime in
short.
for 1 second on that, Kevin. One thing, the administration so far has not defined or even tried to clarify what they mean by illegal DEI versus legal DEI. But the courts have, and there's a lot of precedent to state, not to suggest, but to state that there are a lot of DEI related initiatives that are lawful under existing precedent. And that will likely continue to be lawful under existing precedent. It doesn't mean that the administration is going to like them, is not going to attack them, is not going to try to take some adverse action against them. But in terms of legality, not all DEI is unlawful. And so that's really something to keep in mind, because what we're seeing, like, for instance, if you receive federal funds now, a lot of federal fund recipients are having to certify under penalty of perjury and with False Claims Act liability, which can be civil and criminal, that your organization is not engaging in any illegal DEI activity. And this is applying to subcontractors and subgrantees as well. And so it hasn't been fully implemented, but we're certainly seeing it on an ad hoc basis. And so this is an important consideration, because if you are a direct or indirect, federal award recipient, and you have to make such a certification on behalf of your organization, that's an important distinction between legal versus illegal DEI activities. And we're going to have to just keep a close eye on how things progress and what the administration says and does and how the courts react. All right, sorry, Kevin.
No, it's fine. That's actually what I was just getting into, that point, is that if you're parsing the language of the executive orders a little bit more closely, you'll see that, they stop short of declaring that anything that is, that has the terms DEI is illegal. They don't actually say that. They refer to initiatives that are, discriminatory. And we have a significant body of law telling us what is, illegal and discriminatory under the Civil Rights Act. So, they then start using the terms illegal DEI with a little bit more of a narrow focus. We've seen some kind of distillations of this policy in a few different places that offer us a little more guidance without, being very explicit about it. The first being Attorney General Pam Bondi issued a pair of memoranda to U.S. Department of Justice personnel immediately after taking her office, and clarifying that certain observances, whether they're educational or cultural or historical observances, are not illegal DEI under the law. She used recognition of Black History Month as an example of one such observance that is not illegal DEI. We've also been seeing guidance from the Department of Education directed towards colleges and universities, but also to state and local education departments that initially had been very broad in terms of what it called illegal DEI. But then the lawyers got involved, and some of those things were pared back to really just be describing things that are illegal under existing law that we already know about. Again, Civil Rights Act of 1964, and all the law that has come out of the Civil Rights Act. So when the directive came to state and local departments of education that their funding was at risk, we actually start seeing those legal footnotes in these guidance documents that is limiting that application to the laws we just talked about. Again, it seems that once the lawyers at these federal agencies get involved, they see that they can't make these broad sweeping illegality claims, and that they actually have to base their interpretation in the law. So it's important to note that executive orders do not themselves create law. They may direct the administration on how to enforce existing law, but they are not new law in and of themselves. And that's a reality that many administrative agencies are starting to grapple with. And then, the last kind of development in terms of the interpretation of these executive orders has been in federal litigation. A federal court in Maryland enjoined the enforcement of portions of these two executive orders. After the plaintiffs had made various claims on constitutional grounds. Namely the First Amendment, free speech grounds, Fifth Amendment, due process grounds, claiming that the executive orders were unconstitutionally vague because it did not define what illegal DEI means, and also under separation of powers concepts. That injunction was stayed by the Fourth Circuit on appeal. So that the appeal can work its way through the courts. But the judges there agreed that there may well be enormous constitutional violations, but they said that it has not been enforced against any of the plaintiffs in ways that may mean that this case is not really ripe for consideration yet. But it definitely highlights the concerns that judges have with the breadth of these executive orders and the possible constitutional claims. So, before we get into kind of some of the higher risk areas, I did want to back up one more second into the Students for Fair Admissions cases, the affirmative action cases at the Supreme Court in 2023. And because those really form kind of another cornerstone when we're looking at, when we're evaluating our nonprofit clients, DEI programs. And those cases, really said that because colleges and universities are recipients of federal funds through receiving student loan proceeds, they are subject to Title VI of the Civil Rights Act, and they are not permitted to engage in race-based discrimination. They are permitted to engage in race-neutral considerations of diversity and to encourage pipeline programs that will develop a broadly diverse class of students. But race cannot be an outcome determinative portion of that consideration. So, since 2013, we've been helping our clients apply this ruling to their existing programs, really encouraging our clients to take a broader look at their programs and to think about diversity as broadly as possible and not let race be an excluding factor in any way, shape, or form, however well-intentioned that program may be. But initially, when these decisions were handed down in 2023, there was a lot of speculation about this ruling kind of expanding into other areas of law. This kind of reverse discrimination kind of logic, finding its way into other legal cracks, so to speak. And we're starting to see that in some ways, particularly in the area of employment and Title VII prohibitions on employment discrimination, but also we're starting to see the Title VI piece be interpreted a little bit differently. Some of the recent litigation by the same group against other nonprofit organizations that operate scholarship programs are saying that 501c3 organizations, because they can accept tax-deductible contributions from their donors, that they qualify as recipients of federal financial assistance and thus are subject to Title VI, just the same way that colleges and universities are. Now, this decision relies on a pretty obscure district court ruling from the 1970s, but it's something that they've dusted off to make tax exemption a hook for applying these federal civil rights laws in the way that they have. So Jeff is going to get into a little bit more about the tax exemption implications for nonprofits and associations, but that's just another area that we've seen kind of be a little bit more distilled for us through various litigation that's happening all around the country. So I'm going to turn it back over to Jeff. He's going to talk a little bit more about the primary risk factors that we see for nonprofits and associations, whether it's federal funding, employment, contracting, state law, and tax exemption. So thanks for bearing with me through a little bit of background information, but now we're really going to get into the meat of the risk analysis, and Jeff's going to take us there.
Yeah,
Thanks,
Kevin, could I ask a quick question?
Sure, shoot.
Thank you. Tony Weiler from North Dakota. What I'm understanding you say is that order that specifically mentioned that the DOJ must identify 9 state and local bar associations with DEI efforts within 120 days. That's coming up soon. It's enjoined, but it's not enjoined because it's not ripe yet. Is that what I understood you to have said?
It's in a bit of a gray area right now. It was portions of the executive orders were enjoined by the district court. The injunction was stayed by the Fourth Circuit. So they're back in effect right now. But at least part of the rationale for the stay was that there hadn't been any examples of specific enforcement against organizations that would lead them to have kind of a claim that would justify having that injunction remain in place. So that was where the ripeness aspect came in, is that no one could point to it being enforced against anybody. So, if the Department of Justice and other agencies are going to stick with that timeline in terms of naming certain enforcement targets, then, those organizations are very likely to quickly have a claim that it's being enforced against them. And that whole calculus around enforcement and, ripeness definitely changes a lot. So, unfortunately, we can't speak to that until some of that enforcement activity starts happening, but that's where we are right now.
Okay, thank you.
Yeah, and I know it's a good question. And by the way, that forget if it was the Pam Bondi memo, I think it was, it didn't say for DOJ to identify 9 bar associations. It whatever the number was, it was talking about a broad category of whole different types of nonprofit organizations, of which bar associations were one of, in a list of like 10 or something like that. And they were also primarily seem to be focused on larger organizations. But let's move on to some of the nitty-gritty legal and other risks that your associations may be facing or are facing right now. And we are evaluating this on a daily basis. Kevin, we probably up to about 25 so far, either analyses for different associations and nonprofit clients that we have done or in the process of doing, to evaluate all of their different DEI initiatives, and evaluating where the risks are and what they can do to deal with those risks. And by the way, I saw that question about C6s, and I'm going to be getting to that. So first off, where are some of your biggest risks? Well, certainly, and this is nothing new. It's nothing to do with this administration. Although, like I said, this administration is certainly fanning the anti-DEI flames, and that's in the employment space. In the employment space, especially based on the reverse discrimination rationale of the U.S. Supreme Court's 2023 affirmative action decision, there is no question that any sort of what I don't really like the word, but any sort of reverse discrimination in the employment setting is probably going to be suspect. There was a case that was argued before the U.S. Supreme Court about 6 weeks ago, involving a straight woman who brought a claim that she was discriminated against and was fired in favor of, and first passed over, then fired in favor of 2 gay women, and that she was reverse discriminated against. It should not have a higher bar to satisfy in order to get into court on that claim. Based on the oral arguments, it seems like she's going to win that case. That's going to be one more case down this path, and I think we're going to see more that will take that same line of reasoning from the 2023 college admission decisions and apply it in the employment setting. So to the extent that you have any employment policies or practices that give any preference or advantage based on race, that give any sort of internal benefits or promotions, any sort of tangible benefits based on race or other protected characteristics, those are likely very much legally suspect right now, and you're going to want to take a hard look at those. As you know, employment law is going to be enforced by the EEOC and the U.S. Department of Labor at the federal level, by state departments of labor, as well as by private plaintiffs. We've already seen in the last month or so the EEOC sending out letters to dozens of nonprofit colleges and universities warning them about their DEI practices in the employment setting. I think that's a huge risk area that's not being talked about that much, but we've seen it in our reviews. It's a big risk area. Another big risk area is contracts. And you may say, what the hell is risky about a contract in the DEI setting? Well, the reason is that the original Civil Rights Act of 1866 contained a provision, Section 1981, which was designed to help protect the rights of the then newly freed slaves to be able to earn a living in business, and it made it illegal to discriminate in contracting on the basis of race. It's a provision, unlike the Civil Rights Act of 64, cannot be enforced by DOJ or any state agencies like AGs, can only be enforced by private plaintiffs in litigation And for for decades and decades, it was only enforced against say minorities who were discriminated against on the basis of contracting. But the same gentleman, Ed Blum, who brought the Students for Fair Admissions case to the Supreme Court 2 years ago and was victorious, he formed another conservative nonprofit called the American Alliance for Equal Rights. And that group has been bringing litigation, private litigation, against organizations such as the Fearless Fund, which is a nonprofit organization based in Atlanta that gives that was giving $20,000 grants to Black women-owned small businesses. His group sued them, saying that that was illegal race discrimination and contracting because there's a contract involved in those grants, and that discriminated on the basis of race because, for instance, white women-owned businesses were not eligible for the grants. Ed Blum's group got a favorable 11th Circuit decision, and then Fearless Fund ended up settling the case. A nearly identical case was brought just about 5 weeks ago against the American Chemical Society, which is a 501c3 professional association, a very large one, which made a similar Section 1981 claim, claiming that the scholarship programs that ACS offers, they have a whole bunch of scholarship programs, well-funded scholarships, which are limited, generally limited based on certain protected characteristics, including race, claiming that those violate Section 1981 because there are contracts involved in those scholarships, which there likely are based on the 11th Circuit decision in Fearless Fund. That case was brought by another conservative nonprofit called Do Not Harm out of Virginia. Makes the same claim. They also brought an additional claim in that suit, a Title VI claim that Kevin explained earlier. That's the only one that I've seen filed in court. To us, it seems like a pretty weak claim that because ACS is a C3 and can receive tax-deductible charitable contributions, is that the equivalent of receiving federal financial assistance, and therefore they're subject to Title VI. And Title VI says you cannot discriminate on the basis of race. So it's basically an additional claim in addition to the 1981 claim. We'll have to see how those claims play out. Do Not Harm, by the way, also brought a case against a client of ours. They filed a claim with the Department of Health and Human Services, Office of Civil Rights. Can't say the name of the organization, of course, but they brought a claim alleging that our client, which does receive federal funds and has a scholarship program that's limited to people of certain protected characteristics, is discriminating against individuals that don't have those protected characteristics, and therefore there's some adverse action that should happen. That's brand new. We just got the notice of investigation recently. We'll have to see how that plays out. So this whole line of attack on organizations, nonprofits that have grants or scholarships or fellowships, which involve a contract in which discriminate on the basis of race for Section 1981 and race, color, or national origin for purposes of Title VI of the Civil Rights Act of '64. There's some real jeopardy here, we think. And so if you have any sorts of programs like this, you really need to take a hard look at them, both for potential enforcement from federal agencies, as well as from private plaintiffs like American Alliance for Equal Rights and Do Not Harm. Speaking of American Alliance for Equal Rights, the Ed Blum group, that leads into another category of potential risk. And I say potential because we've seen no actual adverse action taken yet, but it's the federal tax exemption front. A couple weeks ago, we noticed in the Wall Street Journal, the editorial features page editor wrote an editorial basically encouraging the IRS, kind of a weaponized IRS, to use a 1983 U.S. Supreme Court decision called Bob Jones University, where the IRS had revoked the 501c3 tax-exempt status of Bob Jones University because Bob Jones University was not allowing Black students into the university, and later wasn't allowing. It allowed some Black students, but not those that were that had interracial marriages. The IRS took the position that because there was clear federal policy that made such race discrimination highly illegal and against federal public policy, that to allow an organization to have C3 status, that clearly was contrary to that public policy was not permissible. Ultimately, the U.S. Supreme Court agreed with them and revoked the tax-exempt status of the of Bob Jones University. What the Wall Street Journal editor was basically encouraging the IRS to do is to kind of flip that case around, flip the rationale around, and say that the IRS should start pursuing and revoking tax-exempt status of C3 organizations that are engaging in significant they're engaging in significant like illegal DEI activity, or that are engaging in illegal anti-Semitic activity, or other things that are contrary to public policy. He didn't give any other examples, but you can imagine some other types of public policies, relating to, say, abortion rights or immigration rights or other things like this. Gun control advocates, other things that the IRS and the administration could well deem to be illegal or contrary to public policy, and encouraging them to revoke the exempt status. Almost following the editor's lead, American Alliance for Equal Rights filed 3 complaints with the IRS and made them public in the last week. One against the Bill and Melinda Gates Foundation, which has a scholarship program that is limited to people of certain protected characteristics. Similar for 2 other foundations, C3 foundations, making the argument that it's the IRS has a complaint form you can fill out and file if you want to encourage the IRS to pursue some sort of tax non-compliance, and basically encouraging the IRS to revoke the exempt status of the Gates Foundation and these other 2 foundations because of their illegal race discrimination in their scholarship programs. Now, and it was accompanied by very detailed letters from the law firm that they retained, kind of laying out all the legal arguments and basis for why the IRS should do so. We don't know what the IRS is going to do. We never do, because they're not allowed to publicly say anything about whether they're going to pursue an audit, whether they have, whether they will. You only learn about it by law if an organization actually gets revoked. In the end, that'll get published publicly. Other than that, it's kind of a black hole. But in the current climate, there are a lot of folks who believe that the IRS might actually act on these complaints and pursue this. Now, we do believe there's some real legal challenges and deficiencies in these arguments. This is not Bob Jones University. But again, in the current climate, it's really hard to say where this is going to go. We also heard some rumblings this week from several different sources that there might be an executive order next week that encourages the IRS to revoke the C3 exempt status of certain groups that it believes are acting contrary to public policy, including conservation groups. Also potentially curtailing the international grant-making activities of private foundations. We don't know if there's any truth to these rumors and innuendo, but we've heard it from enough places now. It makes me think that something is in the works. And then someone asked about C6 status. So the rationale underlying Bob Jones University is really limited to C3s, which have an obligation to act exclusively for C3 purposes. That exclusive standard does not apply to C6s. So it's hard for me to imagine how the rationale of that case could apply to the IRS revoking the C6 status of an organization, even one that it believes engages in illegal DEI activities, unless those activities were so significantly a part of everything they do. But regardless, it may be more of a theoretical exercise, but what's not a theoretical exercise is that there are discussions right now on Capitol Hill about narrowing or curtailing or eliminating 501c6 tax-exempt status altogether as a revenue raiser as part of the tax bill that's working its way through the Hill. There are also talks about narrowing the exceptions to unrelated business income, such as for royalties and corporate sponsorships and qualified convention and trade show revenue. ASAE and others have a large coalition that's been lobbying on these issues for months now, but it is a very real threat and something to very much keep your eye on as C6 organizations, which I presume that most of your organizations are. And then finally, the last kind of area of legal risk has to do with state laws and state executive orders. There are many bills that have been introduced in particularly red state legislatures to kind of enact more anti-DEI laws at the state level. And we've seen in the past some executive orders from red state governors in this area as well. These tend to be much broader because of the broader authority that states have over private nonprofits, and something to very much keep an eye on, and things like banning any DEI related training of your staff and things like that, of which there already are some laws and executive orders on the books. One in Florida that does apply to private nonprofits, but that one is on hold from a federal appellate court. And then the last area is not an area of legal risk, but it's an area that we have addressed in every single memo that we've done for clients. And that is, and it's something you can't ignore. We need to come up with a good name for this category, Kevin, but it's business risk, it's financial risk, it's attendance and participation risk, member relations risk. And we're seeing it play out every single day. We're hearing from clients about this, that certain folks say they're not going to renew their membership if the organization continues with some DEI initiative, or they're not going to attend a conference if there's a DEI session or track at the conference, or they're going to pull their sponsorship or withhold their funding. If it's a sponsor, we've already seen it happen, or some of our clients came out with some statements, like in opposing the administration on the DEI front, and then they immediately hear from a big sponsor that they're pulling their sponsorship and canceling it. So these are very real risks that you need to consider, even though they're not legal risks. And there's a lot of things that our clients are doing or have done in this area that really we can't point to any real legal risk from it, or any legal risk at all. But where we are very, we have to raise the fact that it has a lot of this business, financial, member relations risk. It also can sometimes make you a bigger target, even though it's not a legal violation, can make you a bigger target for federal and state regulators, for private plaintiffs. And of course, we just saw what happened this past week in your world, where the Department of Justice announced that its attorneys are no longer going to be able to attend American Bar Association events because of how DOJ views presumably the kind of left-leaning tendencies of the American Bar Association. So all this is to say, and we've said this, Kevin, in every memo I know, do not abandon your core values. Don't change who you are and what you stand for. But at the same time, if you have some clear legal risk, like in the employment or the contracting area, you need to deal with it. And there are ways to deal with it. We've given our clients suggestions not to abandon those initiatives, but to structure them in different ways with different eligibility criteria that still achieve your core goals, but doing it in a way that mitigates legal risk. And then beyond legal risk, you got to evaluate all of that business and financial and member relations risk, balance it against your core values, but also against your risk tolerance, and figure out, are there some maybe superficial changes we can make in how we label something, how we describe it in a way that doesn't abandon the core program or initiative and keeps your core principles, but maybe does it in a way that attracts a little less attention. So why don't I stop there, and let's save the rest of the hour, the next 20 minutes for questions.
While we get some kind of questions moving in, Jeff, I wanted to just add one more thing to what you were describing as the non-legal risk, business, financial, member relations, reputational risk. Is that we're seeing a lot of clients that are between a rock and a hard place. They recognize that if they proceed with a DEI program that they have currently planned, they may, raise their risk somewhat, because either they're going to be a larger target, or, some members are going to be upset by it. Some members may be pulling back for business reasons. But also, if they get rid of that same program, they still may have those same risks, because a whole other segment of their membership might revolt for, because they value the association's commitment to DEI principles. So, that really becomes a almost like a governance task for an association to really say, okay, is this core to what we do and what we stand for, and how stiff is our spine on continuing to do these activities, how much financial exposure do we have as a result, that's kind of what the risk analysis comes down to sometimes, is where does this fit in with the strategic direction of the association. But also, some of the things that we were talking about in terms of federal funding are flowing down to organizations that don't actually receive federal funds. But if their members do, or if their members' funders receive federal funding, then that could, be a kind of a second, third-hand risk for associations. You know, if that sponsor is a significant federal contractor and they're a little antsy about any DEI content, they may not be sending people to a conference. They may not be, you know, sponsoring things quite so broadly. The same thing goes for, you know, federal employees who may be members of an association. You know, the DOJ's order about you know, ABA dues, I think, highlighted that one, you know, with a you know, pretty well. I don't think I need to get into it any more than that. But you know, it's those second, third, fourth hand flow downs from the federal funding issue that is also starting to become a financial risk piece for a lot of associations.
Yeah, Kevin, that's a great point, and I neglected to say that. You know, we have one client who was concerned about their DEI tracks at their upcoming annual conference. You know, the client we're talking about. But then they have another small but vocal segment of members who said, if you eliminate these tracks from the conference, we are going to boycott it and we're going to get very loud about it. And we're seeing this in other associations as well. And I was just on the board call with a board of an association that's all of their members come from colleges and universities. We have a lot of associations in that world. And while the association itself doesn't get federal funds, all of their members come from universities and colleges that do get federal funds. And some are state universities as well. And they're trying to balance all these considerations because one of their biggest financial supporters, big sponsor, seems to be very gun shy about you know, certain initiatives, and the board was debating whether to put out some sort of a statement opposing what the administration is doing. And someone said, look, if you do that, there's a very good chance this huge and important longtime sponsor of ours, who is a contractor with a lot of our member universities, is going to pull out. And so you have to balance all of these things. It's not easy, but this is where it really is incumbent on the boards of directors of your organizations to make these tough judgment calls. And I know you guys are the folks who run the associations, but you need to bring your boards into this. There's no substitute for that. These are such tough judgment calls, not the legal risk part, but the non-legal risk. So I'd encourage you to get your boards very much up to speed.
Jeff, we've got one question that popped in. I'm gonna shoot this one over to you.
Yeah, I'm looking at it.
You see it? Okay.
Yeah. I've heard folks advocate to look at activities and programs through the 3 Ps lens: preference, protected class, and palpable benefit. Is that a solid place to start? I mean, it's a solid place to start. I don't know if that's the only lenses that I would apply to these things. You know, as you can hear from what we just talked about, there's more lenses than that that you have to evaluate. But, you know, that whole risk analysis, legal, business, reputational, financial, all of it, your core values, you know, and your members who are on both sides of these issues. You know, you have to take all of that into account and make a judgment call. I don't know that there's some, you know, you've all heard of like SWOT analysis and things like that. I don't know that there's anything that simple. It's a very complex analysis. It's a very difficult analysis. It's very painful. The board that I met with this morning was really pained. Some of their board members have been for decades leaders in the DEI movement, and this was really paining them to even have these discussions. But they recognize these are difficult but important discussions to have. I know some of you must have some questions.
Go ahead.
Either just unmute yourself and just ask, or put them in the chat.
Oh, good luck.
What are the implications for organizations that are focused on one class or area? I'm thinking diversity bars like Black women lawyers. Yeah, so this is a tough one. And it's one that we've been advising on and we've been asked questions on, including in webinars like this. And we actually have a number of association clients that are associations of women in, you know, pick your profession, and sometimes even subspecialties. Like you talked about Black women lawyers in the question. The one thing that we have heard, like we heard this from the EEOC and some guidance that they put out recently, and they were talking about like voluntary employer, like special interest groups where, you know, the larger employers will have special interest groups of employees that are organized around race or sexual orientation or other protected characteristics. And what they said is if you want to avoid liability for creating a hostile work environment for people who are not in those groups, and you need to be sure that, well, A, that a hostile work environment is not created, and B, that eligibility and participation in those groups is open to everyone. And that's the same advice that we've been giving to our association clients that are organized around certain protected characteristics like that, is to, in fact, we're working right now on a bylaw amendment for one group to open them. They're actually already technically open to anyone. They don't have a women-only requirement for membership, but they're going to expressly state it in their bylaws that it's open to anyone, men and women alike, and any gender identification is going to be eligible to join their organization. You know, I think Kevin referred to this earlier. Anything you can do to eliminate any exclusionary practices based on protected characteristics is going to be the wise thing to do, whether it's tethered to some potential legal violation or not. Doesn't mean you abandon your, you know, certainly not you don't have to give up your association. Now, is the IRS going to end up pursuing the exempt status of organizations like that? If you keep them open to everyone, it's going to be a lot harder for them to do that, even if they go down that path. Now, there are certain other organizations whose really only focus is, and not really associations as much as other C3s and C4s, where their whole focus is on DEI advocacy. And those organizations are probably going to have the biggest target on their back. And we're going to have to see how it plays out in the courts. Someone asked, how do you see the risk analysis? Oh, go ahead.
Sorry, Jeff, just before we move off of that one, another strategy that I've seen a lot of organizations adopt is that, if they are an organization that is, at their core, they are focused around a certain identity, then yes, opening up their, eligibility to include everybody is one piece of it, knowing full well that they are still going to continue to attract a majority of that core identity that they already represent. But in particular, when it comes to programs, and whether it's scholarships and fellowships and other things that may involve a contract and confer a tangible benefit, they've been focusing on the work that scholarship or fellowship wants to promote. So they may not be able to say that this scholarship is reserved for for Black lawyers, but as an example, but they may say this scholarship is reserved, eligibility requirements is a consideration of the work that the applicant has done in working with underserved communities or working with, diverse organizations. When you put the focus on the work rather than on the identity of the applicant, that can really do a lot to change the legal analysis about whether that program is permissible, even within the context of a group that exists to serve a specific identity group. So that's been, one thing that we've seen a lot of our clients steer towards.
Yeah, that's a great point. Yeah, someone asked, how do you see the risk analysis change from mandatory versus voluntary bars? I'm sure there's a lot of, I know there's a lot of differences, and I know there's probably some legal distinctions that are important there. But in this area, it's hard for me to think of a lot of real legal, anything that you're doing that's legally problematic or reputationally problematic, whether you're a mandatory or voluntary bar, to me, there's still risk, no matter what. I mean, the risk might be heightened a little bit if you're a mandatory bar, you're kind of amplifying the risks. But I think that all of the same basic advice and guidance that we're giving here should apply. Or if I were someone from a mandatory bar or voluntary bar, I would take it the same way and try to implement it in the same way.
Jeff, I've got one more that came in, but asking that it not be attributed. So here, I'll just read it out. A big issue for some bars is making public statements. Do you have a view or recommendation generally about how to approach or assess when to make such statements?
Yeah, I mean, this is a really tough one, and some of our clients are really struggling with this. You saw, Kevin, this past week, or maybe it was last week, they all run together these days. One of our clients, it's a pretty large, high-profile association. It's not really in the scholarly academic world, but their professionals come from that world. They decided it was really important for them to put out a statement expressing their strong support for academic freedom and scholarly integrity and research and things like that. And they expressly referenced DEI, and they did that on purpose because they wanted to send a statement. I gave you the example of my client earlier, the Association of Folks from the University setting, where some of their board members were saying, we really should come out, because we do feel strongly about these issues, we should come out with some statements opposing what the administration is doing. And then others said, do we really need to do that right now? Do we really need to put an additional target on our back, not just for regulators and plaintiffs, but even for sponsors and attendees and registrants and members and things like that? And so it's hard to say personal when it's an organization, but it kind of is an organizationally personal decision. It's going to be different based on each organization's priorities. I will say, if you decide you want to put out some public statements, there is no doubt it will get attention. We know that federal agencies and plaintiffs' lawyers and others are using AI to scour the websites of nonprofit organizations and other publicly available information. So, there's probably no question it will, in some measure, increase your risk. At the same time, that's really important for some organizations to do. And others have said, look, we are not changing who we are, what we believe in, what our core values are, but we also don't need to go out and say it. And then, of course, finally, we have some clients where there's a big clamor from the members, or segment of the members, I should say, to come out with certain public statements. And I've heard some of these discussions, they're saying, if we come out with something that's so whitewashed and, kind of try to thread the needle and split the middle, it's actually going to anger some people, and we'd probably be better off saying nothing than saying something like that. So I'm not giving you a direct answer, but at least I'm giving you some considerations to take into account. And let your board weigh in on that. Don't just make it as a staff decision. That's the worst thing you could do, by the way, because all of you, we do a lot of work with boards, but we're primarily working with the execs like you. And I've seen this for the last 30 years. Worst thing you can do in a sensitive political issue is to get out ahead of your board, have something backfire, and you don't have the cover from the board. You want to always make these board decisions. All right. Any other final questions?
I've got one more that just came in, Jeff. Would you recommend having, to follow up on that statements question, do you recommend having those statements come from the bar leadership or the association as a whole, or how would you attribute those statements?
I think it's going to be different for each situation. I think either it's got to come from the board as a whole, like not just, for instance, an executive committee, not just signed by the president and CEO or executive director. It's either got to come from the board or just from the organization as a whole. Because as we know, the board is the ultimate fiduciary of an association. It generally speaks for the association, but the association is broader than just the board, it's the members as well. Either way, I think you could say, you really should not be putting out a statement that says on behalf of all of our members, because unless you're really getting all of your members' input, that's not an accurate statement. So I would, probably the safest way to do it would be to make it a statement from the board of directors. All right. Lori, should we wrap this up?
Oh, Laura, you're on mute.
Yeah. So I first want to thank both of you. This has been very helpful, and particular to me because we're getting ready to make a statement. So this is helpful on how to do this. And I appreciate what you've talked about, the bylaws and ways that people can structure the wording so we can still be who we are, but yet make sure that it's inclusive. For everyone else, it has been recorded, and the recording will be available to you at any time. And we also, if it's okay with you and Kevin, Jeff, we'll provide your contact information if people have questions.
Sure, absolutely. And I would say we have a ton of resources on our firm's website. Kevin, can you put our web address in the chat? hundreds of articles, PowerPoint presentations, and recorded webinars on a whole large variety of association and nonprofit legal issues, including, of course, some articles on this topic and some recorded webinars on this topic. And we continue to add more to that. So if you go to the resources tab at tenenbaumlegal.com, there'll be a steady stream of continued resources if you want to keep up with the latest on what's going on here.
Great. Well, thank you again, and everyone have a wonderful weekend.
Thanks, everyone. Take care.